Well, it's 1:01, so I think I'm going to make a start. Good afternoon, everyone. Thank you very much for joining us for this second part of a mediation advocacy smorgasbord of a discussion. The first session was on the 23rd of April, and what we're not going to do because of time is go back through the introductions and explain the purposes of what we're about. If you want to make sense of what we're talking about this afternoon and you didn't listen to the first session, I'd invite you to go back to the Financial Remedies Journal website, and you'll be able to quite easily find the first session, which is free to access, and all of the speakers there introduce themselves. Very briefly, the panel comprises some eminent NCDR or ADR practitioners drawn from both the civil and commercial field and also the family and hybrid field. And hybrid is particularly relevant in this context because what we're thinking about is, what do family lawyers need to do in mediation? Where's the advocacy in mediation, and how does it get done well? And so the session now is going to look at some of the practical and granular aspects of the nuts and bolts of mediation advocacy, which we didn't have time to look at on the 23rd of April. So turning, if I may, first to Suzanne and to ask, what in the first instance would you want to talk to your client about in respect of mediation?
I think that's a really important question, Rhys, and in particular, I think it's bewildering for clients when they come and see a solicitor, and there are so many out-of-court dispute resolution things that could happen. And so I think speaking to the client early on, explaining the options, perhaps not just mediation, but all of the options, and making it clear to them and making it understandable for them in jargon-free language as to what mediation is, if we're talking specifically about mediation, and how it might work, and how in today's world the court will expect the client to have been to see a mediator and to have had the intake session, the MIAM session, to determine whether or not the case is suitable for any form of out-of-court dispute resolution, including mediation, and then proceeding into that rather than proceeding down the court route prior to issuing any litigation. So absolutely crucial that the lawyer explains all forms of out-of-court dispute resolution and explains how the MIAM will work in that context.
Would you mention to the clients the new pre-action protocol?
Yes, absolutely. So that they would be fully aware of their obligations, your obligations under that, to ensure that they do think about all forms of out-of-court dispute resolution and why. I mean, in terms of confidentiality, the fact that you have the option of making your own agreement rather than an agreement being an order being imposed on you by the court. Talking about the situation in the court at the moment in terms of the lengthy delays and, you know, the stress, the emotional and physical stress for someone who's going through litigation and how that could be avoided. So talking through all of that. Great,
thank you. Karen, I'd like to ask you, if I may, about open correspondence in respect of NCDR. Is that something that is just about being as pure as the driven snow, or is there a tactical reason to write some open correspondence offering NCDR?
Well, Rhys, thank you. That's also a very interesting question. I think that we are undoubtedly on the cusp of a costs order being made against somebody for not using out-of-court dispute resolution as an option and going to court unnecessarily. With the new FM5, where we have to give justification as to the steps we've taken in relation to the consideration of out-of-court dispute resolution, it is something that we really need to think about very, very carefully. And following on from what Suzanne has said, and the importance of discussing all of the different options with the client at a first meeting and actually throughout the case, because it's an ongoing consideration. I think it's very important to set out in open correspondence the forms of NCDR that are specifically relevant to the issues in a particular case. I think it's not just to sort of throw around the idea, or we might think about mediation or a private FDR, but actually to set out in your open correspondence why you might be feeling that mediation would be appropriate. Suzanne's mentioned the confidentiality point. I think that even in very high conflict cases, the ability to hold confidences in hybrid mediation and understand some of the depth of the emotional as well as financial or other issues between the couple can be highly relevant and assist in some of the most high complex and high conflict cases. Perhaps if you have an issue of principle, which is more likely to be determined one way or another, it may be that the private FDR is the better option, where you can put to the test and ask for an indication, putting forward both sides of a particular argument in that respect. But I think that open correspondence dealing with out-of-court dispute resolution issues is actually absolutely essential in the early stages of any case, most importantly to show that you have addressed your mind, your client has addressed their mind to what sort of cost-efficient, time-efficient options might be available, to show why you've thought that through, to make it clear that you've suggested to the other side that they might want to engage, you've offered the opportunity, you've provided lists of names of people who may be suitable, so that you can absolutely underline the fact that this has been very, very carefully considered and set out in clear terms so that the other party to the process can make conscious, informed decisions about how best to proceed, given the issues in the case. I think it's a big new change and vitally important.
And could I just ask, speaking as a family lawyer who might be preparing a client to send that kind of correspondence, how detailed would you be if you spoke of a list of possible mediators? How many would you put? 3, 5? Would you put the costs next to them?
I would. I put between 3 and 5. I would set out costs. I might even have checked possible availability, so that I wouldn't be putting forward somebody who turns out not to be available for the time frame that's required. But I think that the easier you can make the job for the other side, the better. So the more informative and detailed it can be, the better, the more helpful that's going to be.
Okay, thank you. Well, that leads us neatly on to Andrew. And if I can ask you, Andrew, for any tips that you would have to how to help a client choose a mediator.
Sorry. You mean other than choosing Stephen?
Other than choosing Stephen.
Okay, so I mean, the choice of mediator is actually one of the 3 vital decisions that counsel needs to make. The first, obviously, being whether to permit the client to mediate. And I use those words advisedly, although unfortunately the decision is probably no longer going to be in your hands. When to mediate and who is going to be the mediator. So let's move on to the last. At the moment, of course, in civil commercial, there are probably between 12 and 15, maybe 18,000 mediators out there who would like your job. That doesn't mean they're all going to be capable, and it doesn't mean they're all going to be suitable. So in terms of the market governs price, and the availability is also a factor. But let's have a look at why the decision is important. Very rarely do we get to pick our judge. In arbitration, we do. in mediation, we get to pick a tribunal of sorts, but we know perfectly well that he's not actually a judge. But the mediator has an enormous influence over the potential outcome of the process. The mediator guides the management of the process, and invariably, if the parties' counsel are not that experienced, then the mediator will take charge very much of the management. So influence is absolutely vital, because influence leads all the way to outcome. And it's firstly somebody that you've got to be able to work with. There's no point pushing against what the mediator is doing. As an advocate, you want to recruit the mediator to your client's cause on the basis you are paying the mediator to get the best deal available for your client. That's the job. Mediators stand or fall on qualification, accreditation, reputation, experience, potentially subject matter expertise. Sometimes you have to decide whether you want a lawyer or a non-lawyer very specifically. And let's examine some of these things very quickly. Qualification. Civil commercial, we still operate in an unregulated environment. Anybody can call themselves a mediator. So it's good if you can establish that the person that you're potentially going to be putting your client's interests in the hands of know what they're doing. So accreditation. Most of the training organizations run an accreditation, and we have CMC as the registration authority. It's not the be-all and end-all, but I'm afraid it's the best we have at the moment. And therefore, I think we need to take cognizance of it. And people who register with the CMC, and people who are not only accredited, but the accrediting organization keeps a record of the number of mediations they've done and feedback which they are willing to share. Experience, I think, is vital. It depends to an extent on the nature of the dispute, and also perhaps the value of the dispute. You're not going to put your client's affairs in the hands of somebody who's only been qualified for 5 minutes. But on the other hand, you really need to understand the person that you're going to be hiring. So reputation, I think, probably trumps the other things. Reputation comes in the form of other members of your firm or other people being freely able to discuss that person, what they've heard about them, whether they've appeared in a mediation working with them, and what the outcome was, to the extent that they can say so without breaching confidentiality. And it's quite likely that a firm is probably going to keep a list of mediators that they will use on a regular basis. You can fall into the comfort of dealing with the same person regularly, and that has advantages because you know how they work, they know how you work, and there's a sort of shortcut which cuts through the whole of the process. But on the other hand, it might be very useful to have the mediator who knows something of the nature of the dispute, so that you have some degree of subject matter expertise, not because you need evaluation, but because you don't want to have to explain the ins and outs of either the legal case or the legal context to a mediator who's unfamiliar with it. But I think the reality is, for me, style is probably the most important. I will know client by client, case by case, whether I want a mediator who is firm and directive, or whether I want a mediator in this particular instance who takes a more laissez-faire approach, laid back, light touch. Sometimes you have a difficult client and you want gravitas, and you want someone that the client is not going to want to argue with, but will listen carefully to and understand, so that you can work with him in order to craft the settlement that's desirable. On the other hand, you may have a very experienced businessman or company director, finance director, chief executive officer. They don't need to be told, because they know exactly what it is they're trying to achieve. And it's simply a question of working together as a team to try and effect that kind of an outcome. I'm afraid this sort of discussion can go on and on and on, but I think those are the bare bones of what one should be thinking about in terms of civil commercial mediator selection.
That's very helpful, Andrew. So that's from the civil and commercial perspective. I'm not necessarily expecting the family lawyers to want to chip in with any other observations, but if you wanted to, Karen and Suzanne, you're more than welcome.
I think I would pretty much agree with everything that Andrew says. You've got to choose your mediator very carefully. And I think one of the things that's occurred in family mediation is the evolution of the slightly more directive mediator. And it may be that that's one of the things you really need to think about. And of course, Karen and I both very well versed in hybrid mediation would also be thinking about whether hybrid mediation was appropriate, and if so, whether a hybrid mediator should be appointed.
Good. Turning then to Stephen, could I ask about the kind of contact our mediation advocate is going to have with the mediator in the run-up to the mediation?
Yeah. In civil and commercial mediation, it's absolutely standard to have a pre-mediation chat with the mediator. It's usually confidential, usually on the phone, sometimes now with Zoom or Teams. The reason it's standard is because it's so important. I mean, most mediators, shortly after they've been appointed, will send you an email saying, when can we have a word? If you don't get one within a week or so, be proactive, contact them. Now, why is it important, either from the point of view of the mediator and the advocate? Well, from your point of view as the advocate, you can find out what the mediator's like. Now, you may have done your research when choosing them, but when you actually talk to them on a confidential basis, you get to know more. You find out what their approach is. How are they going to structure the day? Will they want a joint opening session? We're going to talk about these later. The reason why these questions are important, it helps you prepare your client. And that's something else we're going to talk about later. You can deal with nuts and bolts, the logistics. Where's it going to be? What time are we going to start? Will we have breaks, etc.? But more importantly, you can ask them what material, what documents do they want to receive before the mediation? And that helps you with your preparation. And what you can really do is help shape the expectations of the mediator. Now, you will be doing that with your clients. You want to do it with the mediator. You can start to set the agenda. Tell them the issues that are likely to arise. Tell the mediator things about your clients. Are they nervous? Will they want to see the other side or not? Or are they the opposite? They're very bullish about their case. They're angry. They can't wait to stick it to the other side. Tell them also about constraints in advance, if you know them. Are your clients going to have to leave at 4:30 and come back an hour later because they've got to pick up the kids? Will any settlement have to be run by the finance officer? Andrew made a point about recruiting the mediator to your side, working as a team. Well, start early in your pre-mediation chat. Recruit the mediator as an ally. Tell him if your client is not taking advice. Tell the mediator any personal or professional concerns you've got. If you haven't done many mediations before, say that and ask the mediator for help. They will help you. Also, if you've got concerns about the other side, air them now, not on the day. Say you're not sure that the other side are going to have authority to settle or even got any appetite for settle. Are there any outstanding information requests? Raise those, and you can ask the mediator on your behalf to flag those up with the other side when they have their confidential chat. And be prepared to answer the mediator's questions. So from the mediator's point of view, why is it useful to have this pre-mediation chat? Well, you get to know about the dispute in a nutshell. Of course, it depends when you're having the chat. Are you having it before or after position statements and documents have been delivered? My own view, the sooner the better. And the mediator can find out the experience levels and expectations of the clients and the lawyers. So be expected to be asked, What's the dispute about? So be able to deliver a nice punchy summary. Who's attending? So try and get your list ready. Who will be the decision maker? Because it's not always obvious. And that's what people need to know. Will there be insurers there or directors who need to be consulted? What are your clients' expectations about the process? Will you want a joint opening session? So it's the mirror questions, the ones you can ask. What I always like to ask is, how old are your clients? Because chronologically, where you are in life depends on how you see the future. And of course, it's the future we're talking about at mediations. What are relations like between the clients? Can they talk to each other if need be? What are your relations like with the lawyers on the other side? Are you getting on or not? Ask them what their usual approach is towards mediation. Now, you've probably got a feel for this, but you can just confirm what you think they're going to do. And really, the key question you should be able to answer, why hasn't this dispute settled so far? You will be asked what offers have been made and how is it being funded. That's an important question in civil and commercial mediations these days. So when do you have this chat? Before or after position statements have been exchanged? I think, as I said already, sooner rather than later. You can always have a follow-up chat. And should you include the clients in this chat or not? Well, if the clients want to be included, of course. If you're doing the mediation online, you're probably going to have a dummy run, and that will tend to be with the clients involved. But if it's an in-person mediation, I tend not to speak to the clients without the lawyer being present. And the reason for that is I don't want to get mixed messages or be accused of nobbling the clients. So liaison before the mediation, essential. Take the initiative, be prepared not to find out what you want to know and manage the mediator's expectations, which will help you manage your client's expectations during the preparation.
Stephen, thank you very much for that very helpful analysis. And I suppose if we have some people on the call who haven't done a mediation before as an advocate, it will come as somewhat of a surprise that the tribunal figure, I know a mediator isn't a tribunal, but the neutral figure in the room can be approached in advance in a far more profound way than would ever be possible if you had a judicial figure.
Absolutely. Yeah. It's part of Andrew's suggestion that basically you're trying to build a team for the day. So start team building early on. Good.
Another area of practicality, turning back to Karen, is bundle preparation. And they're the blight of litigation. But do we want a trial bundle, Karen, or are we after something a little lighter than that?
Well, we want a relevant bundle, Rhys, and I think that's yes, you're right. In my office, there's a sort of sense of horror every time some kind of court bundle has to be prepared. And how often do we find ourselves in court, albeit I don't go there very often now, thank goodness, where you have a 300 and odd page bundle and it's only ever page 273 that's looked at about 15 times and everything else is pretty unnecessary. It kind of follows on with the liaison point that Stephen was identifying, in that the mediator can liaise with the lawyers who are providing material to indicate what will be helpful for them to have read, because the mediator is obviously going to charge for their reading time, and they don't really want to be reading through 6 inches of unnecessary paperwork that isn't going to assist them in facilitating the discussion that the couple are going to engage in. So it's a combination of the mediator and those representing the couple to look at what is going to help the mediator understand the issues that they're trying to facilitate a negotiation to resolve, and how important is it going to be to have documents available to support that. So you would have a bundle, but I would suggest it's going to be a very slim and very relevant bundle.
And of course, another point that comes out of all of this is that a mediation isn't a trial, and you're not trying to prove things in the mediation, are you?
No, you're not. And so the only documents that you need are those that are going to be informative, so that everybody can perhaps follow the asset schedule during the discussion, or if there's perhaps a pension report, that it's useful to have to hand to see the options that might be set out in that. So anything that's going to assist, then I would have it readily available. But otherwise, I'd leave it firmly in its virtual file somewhere.
Suzanne, the note. Now, of course, notes and skeleton arguments come in all shapes and sizes in litigation, but there is a tendency, dare I suggest, for an advocate to quite often have quite a full note in litigation. Maybe it'll be 15 or 20 pages, something like that. And what would your advice be for the style and length of a note in a mediation context?
I think in a mediation context, it's really the mediator who controls the process. And I say that advisedly, but I think the mediator needs to determine what the length of the note should be and look for parity on both sides to achieve balance and neutrality. So actually expressing how long they would like the note to be. It might be 5 pages, 10 pages, perhaps for discussion, but making sure that both parties' notes are roughly the same size, and that rather than them being exchanged, they're sent to the mediator for the mediator to review before exchanging them. I do that with notes and also with Forms E, only because once or twice I've had situations where one party has made very full disclosure, for example, on a Form E, and the other very poor disclosure. And so I prefer everything to be sent to me for me to effect the exchange. Of course, we're thinking very much now about jargon and language and the style and what it should be accessible in terms of the note. It should be easily readable for and less positional, less aggressive, and more constructive in its tone in a mediation than you would expect in litigation.
Of course, one of the points in a mediation is that you're not actually trying to persuade the mediator of anything. You're trying to persuade the other side to do a deal with you.
Yeah.
And does that inform the language?
Absolutely. So thinking carefully about how best to position your case to make it something that would be appealing to the other side is absolutely crucial in a mediation.
My preference and usual practice would be to be pretty light on the law. Would you agree with that, or do you take a different view?
No, I agree with that, unless, of course, one of the absolutely key fundamental points in the case is a point of law, in which case you have to get into the law in great detail. But the majority of the time in mediation, I think the law can come into it. You can find yourself in a situation, for example, where you ask the lawyers to submit to you, to say to you what they think the law is in relation to a specific point. Or you might say, well, we could jointly instruct an independent third party, a barrister, for example, to provide their view of the law and bring it into the mediations. There's loads of ways of dealing with that if there is a tricky legal point.
Stephen, mechanics of a mediation. What, as the mediation advocate, would you be telling your client about the forthcoming day?
As a mediator, I would hope the advocate was going to be telling the client, we're going to mediation to make peace, not war. We're looking for the common ground, not the battleground. I find that most people prepare for mediations by spending their time on polishing up their legal case, how they're going to win at trial. We go to mediation to avoid going to trial, so we should be thinking much more about settlement. That's the key point about
That's the tone.
That's the tone. Well, now within that, you're trying to manage your client's expectations. What you, I think, need to do is to make sure they are as comfortable as possible with the prospect of mediation and the process. Now, from the point of view of the prospect, most clients will be nervous and in advance, and on the day they'll be highly stressed. The more familiar they are with what is likely to happen, the less stressed they're going to be. And as a mediator, I find that the biggest single obstacle to settlement to start with are high stress levels. If people are stressed out, they're not thinking about the future, they're thinking about the past. So you assure the client that you're going to there to make peace. They're not on trial, they're not going to get cross-examined. And this comes to the first point about confidentiality and without prejudice. What mediation is a place where they can think flexibly and have the confidence to know that if they don't produce a settlement on the day, what's been said cannot be referred to. And that is really important. Quite often, I find that at mediations, without prejudice hasn't been explained to clients. Now, of course, I accept that you don't have to do this with every client because some of the most sophisticated users of mediation, what I'm really talking about is one-off visitors to mediation, never been before or never go again, and are stressed out by the whole idea. That's why it's quite important to have this early conversation with the mediator so you can pass on to the client what the mediator's like and what the mediator's going to be expecting. One thing that I think is very important is for the clients to start appreciating that what they're going for is a negotiation, and it's an assisted negotiation, and the mediator is there to assist them. They need to be taken through the process of working out what a good outcome for them could be, and then to be able to translate that into offers. It's very difficult when clients are asked to start thinking about their first offer on the day of the mediation. So, in summary, what I would want the advocate to be doing is emphasising we're there to try and come to an agreement, that what's said can't be referred to later so people can speak freely, and that the mediator is there to assist them.
Stephen, you mentioned offers and the timing of offers. Are you in favour of written offers in advance of the day, or do you think that everybody should have to wait until early afternoon for an offers to be exchanged?
Well, there's two types of offers. Those have been made before the mediation and not accepted, which of course is why we're going to mediation, and those offers which are being made in the contemplation of mediation or as part of the mediation. I know that there are some mediators who insist on mediation offers being exchanged beforehand. Frankly, I don't think it's a good idea. It can cause rigidity of thought. Better for the client to, let's get this on the table. Most mediators have never met the client before. The client needs to feel comfortable with the mediator. So probably the first hour of the mediation, both rooms, they're weighing up the mediator. They want to know they can trust you. So they're not really going to want to make any offers until they know that they can trust you. I don't think pre-mediation offers for a mediation purpose are helpful. I do think that early offers during the mediation are very important. Certainly, I like to have a simultaneous exchange of offers before the sandwiches arrive. Simultaneous, so that no one thinks they're bidding against themselves. And please bear in mind that prior offers which have been made and not accepted form part of people's mental furniture. They're in their minds. The paying party comes to the mediation expecting the receiving party to come down. The receiving party expects the paying party to go up. So when you make an offer, think what message or signal you're sending to the other side.
And in just one final point, if I may, on this topic, Stephen, the pace of offers, sometimes it can be frustrating. Maybe there's one side that is very clear and can make decisions quickly. And then there's another room that, for very good reasons, is far slower, more ponderous in decision making. And I sometimes wish we had a chess clock in mediation to keep the pace going.
Well, I agree with you. Sometimes there are good reasons. Often there are not very good reasons. A good reason, for example, will be the difficulty of getting hold of the insurer to sanction the offer. Yeah, there's inbuilt delay. A not very good reason is because no one's thought about settlement before they've come, and they're treating the first session of the mediation as a conference with counsel. Those are not good reasons. I keep an offer log and a time log of my sessions, so I can say, look, it's half an hour since I last came to see you. And I try and keep the momentum going without annoying people. I don't always succeed.
Yeah. So turning back to Andrew, if I may, what else the advocate is doing on the day, and what kind of advice is the mediation advocate having to proffer as the day develops? Andrew.
I think you've asked two different things, Rhys. I think what we do and what we say to the client are not necessarily the same, but they are working in tandem. I mean, I absolutely endorse everything that Stephen has said, both in respect of a pre-mediation call with the advocate and what the mediator is trying to get them to do during the course of the day. I think it's absolutely vital that there is a pre-mediation conference with the client. Doesn't matter whether the value of the claim is tuppence halfpenny, it's not cost effective to have the client in. The fact of the matter is this day is so important, and it's so different from trial advocacy. It's absolutely vital that there's a pre-mediation conference. So what I would be saying to the client is a pretty much a rehearsal of what we've already discussed. I certainly would want to remind the client that this is not a vehicle for deciding who is right and who is wrong in the dispute. If necessary, that would have to take place on another day, but not today. This is an opportunity to make the client better off than they are at present. And I think that's got to be the theme going into the day and at the beginning of the day. I do agree with Stephen that there are occasions when the advocate either believes or thinks that it helps to have a very polished case to be able to argue it in the presence of the mediator as part of the negotiation phase. But I think that's got to be subsumed to the true interests of the client, which in fact the lawyer may never know. The lawyer may never know things that the client does not reveal and hasn't revealed, because the client assumed that the lawyer's focus is on the case and not on his wider business interests or his personal relationships or his health or his management time or his opportunity cost. I think what you have here is the pragmatic side. The pragmatic side is making sure that the client goes into the day knowing what he's trying to achieve. What he's told you he's trying to achieve and what he actually wants to achieve may be different things, but I don't think that really matters. He's got to arrive with some degree of focus in respect of outcome. He's got to be confident that he can speak when the mediator asks for an opening statement, or even can answer questions with some degree of accuracy about the things the mediator wants to know. I think that it's absolutely pertinent that the client's got to trust the mediator. And to an extent, the lawyer is protecting the client's or defending the client's interests up to the point where the client is confident in the rapport that the mediator's built. There is a little bit of edginess with the lawyer on the basis that he's not really sure the extent to which the mediator might be manipulating the client to an extent. I know it sounds pejorative. It's obviously not pejorative if you're an osteopath or a chiropractor. So I use the word manipulator on the basis that it can be equally a neutral assertion. I think you're discussing with the client what it is that the mediator is doing. And if you approve of what the mediator is doing, then that's all very well. But remember, in the caucus scenario, you're not going to be with the mediator all the time.
Could you just explain for people who don't know what the caucus situation is?
So the private meetings between you and your client and the mediator, which do not take place in the presence of the other side, and which enable the mediator to discuss in complete confidence things that are of importance to the client.
Could I ask a further question, Andrew? For the mediation advocate, should advice on prospects, the law, outcome, in your experience, are those things safe to advise your client about in front of the mediator, or should you invite the mediator to step out of the room?
Good legal answer, it depends. It depends entirely where you've arrived. I mean, personally, I'm very happy to trust the mediator, but they have to earn that trust. And I can't tell you whether they earn that trust within 5 minutes or an hour or 2 hours. And if I'm working with a mediator I've not worked with before, but which I have commissioned because of their reputation or because of their subject matter expertise, it's going to take even me a little bit of time to bed in, let alone the client. So I don't expect anything great in the first period, as Stephen would say. But I can watch how the mediator is working. And if I'm not happy about it, then I will say to the mediator in terms, in front of the client, or if necessary, in private with the mediator, and I will carry forward my client's expectations. But what I'm doing at the same time is I'm looking ahead and I'm trying to measure outcome. After all, as an advocate, I have the opportunity of seeing people on the other side, measuring them, understanding what they might look like in the witness box. I have the opportunity of gauging how good a lawyer we have on the other side. That's going to have an impact on me, because at some point, the client's going to say to me, well, should I take the offer or not? And I'm going to have to explain what the alternatives are to a negotiated agreement based on offers that are coming from the other side via the mediator. Now, by that time, I expect to be able to discuss fully and freely and in the presence of the client, the offers, how they're formulated, what they amount to, what bits might be acceptable and what is not going to be acceptable. But I'm going to be doing this as part of a team. I'm not simply going to be doing it because I might be more articulate than my client is. And at each stage, when the mediator is absent, I want to see how my client is feeling. I want to discuss his expectation. I want to see whether the expectation has changed as a result of anything that he's heard. Very often you're going to a client who says at 11 o'clock or 12 o'clock, this is a waste of time. What are we hanging around for? Or when the first offer comes and it's completely unacceptable, the client's going to say, look, this is a complete and utter waste of time. I think we need to go. You as the advocate have to measure what the alternative is going to be if the client walks out the door. And you do that right through the day, right up to the last offer, which the client finds acceptable. But you're not doing it as the team leader. You're doing it as a supporter, which is unusual for the lawyer. And some lawyers find that uncomfortable, and they don't understand that to an extent they have to give control of the client away to the mediator so the mediator can do the job properly. But then they've got to just be there as the wingman to intercede if they think that the client's interests are not properly being protected.
Perversely, at some point during the day, the best thing that the mediation advocate can do is just shut up.
That of course that brings another problem, because how does the advocate demonstrate to the client that they're earning their fee if they're just sitting there and not saying anything, particularly if they're charging an hourly rate? I mean, the true answer is everything is in preparation. You should have earned your money before you arrive at the place, and the rest of it is simply working your way through the process that you know is going to happen. I think you need to explain to the client that there will be times when he is engaged in a conversation with the mediator and you are not going to participate, but you are simply going to watch and listen and perhaps advise after the mediator has left. And you don't want the client to panic because you're not banging away at your case. Because remember, the case is only one level at which the problem is going to be assessed. You are not there to fight the case. You are there to help solve the problem to the extent that the client finds acceptable.
Thank you, Andrew. Turning back to Stephen, if I may, Andrew spoke a moment ago about a caucus session, namely a private session with counsel or the mediation advocate, the client and the mediator. But then there is also in the books the plenary session, the opening session, or maybe a session some way through the day when everyone comes together. Excuse me. And I'd just like to ask you, if I may, Stephen, about your experience of plenary sessions. Are they common? Are they in vogue? Are they less in vogue? How helpful are they? And what are your observations about them?
Right. 3 types of joint meetings, plenary sessions. The joint opening session, the traditional type, the joint working session at some stage later in the day when you've got some traction, you're trying to sort out a particular issue, and sometimes a joint review session. You've got to a certain stage, but you're getting stuck. So as the mediator, you call everybody together and say, look, we've made this amount of progress, but if we're going to get to a settlement, we've got to close this gap. This is what I want people to think about. 3 types. The joint opening session is the one that mediators in the UK are trained you must have. It's not a proper mediation unless you have a
civil mediators. Yes,
all mediators must have. It's not a proper mediation unless you have one. Now that, in my experience, is now old-fashioned. Those types of conventional opening sessions where everyone was together, mediator ran through the ground rules and then asked people to say whatever they wanted to say, are pretty well in civil and commercial mediations finished. They were going out of fashion even before COVID and lockdown, when we all went on screen, and since then they've pretty well become extinct. Why? Because the lawyers could not resist the temptation to attack each other's clients. And you know
spear waving.
And you know what happens when you're attacked. Your blood pressure goes up, so do your defenses. The last thing you want to happen at mediation, you want people to open up, not close up. So in my experience, they're going out of fashion. There are mediators who think they're a good idea, and some insist. And I agree, there are times when it's a good idea to have a joint opening session. For the first thing, it gives you, as the advocate, the chance to assess the other side. Oh, what are they going to be like as witnesses? People are always telling me, I want to see the whites of their eyes. Or, as someone said, I want to smell their fear. Now, that was an American lawyer, so okay. But is it all about, in fact, trying to get your retaliation in first and intimidation? And sadly, sometimes it is. The worst example was counsels asked the client on the other side, are you an honest man? The reason I'm asking that is because I'm really good at cross-examination. And the last person I cross-examined committed suicide. Well, you can imagine what that did. And you can see why that sort of forum is, it's had its day. But sometimes the clients want to feel they've been heard publicly. There's a cathartic element. And the mantra is suppressed emotions, sabotage mediations. Well, they can. And so sometimes that's a good idea. Also, sometimes the person who's going to be the decision maker on the other side hasn't been involved in this. They don't know the detail. They've just had their own side's filtered version, and you can give them your filtered version. And with that point in mind, work out who you are addressing, who you want the message to get to. Is it the mediator, the other side's lawyers, the other side's client, your own client? I think it's the decision maker on the other side. And what you want them to do is to think, hey, this guy is someone we can do business with. Maybe I would even instruct them in the future. So don't tell them their case is rubbish. Don't tell them they're doomed to fail. Don't present your case. Instead, give an overall assessment of the situation from both sides, acknowledging points and interests. And that, given in an even-handed way, in an even tone, is going to be more beneficial, more persuasive than a partisan, tendentious demolition of the other side's case.
Thank you, Stephen. Can I just turn to the family lawyers for a moment? Of course, in traditional family mediation, the parties, of course, are together most of the time. And would you just like to make any observations about joint sessions in the hybrid context?
Yeah,
You go ahead, Karen.
I think that they're very useful in the hybrid context. And I think part of the skill of the hybrid mediator is knowing when to bring everyone together and how productive that's going to be. Suzanne, would you agree with that?
Absolutely. I mean, I think we're seeing more and more, aren't we, lawyers attending as well. So I know we're drawing the distinction now. Hybrid is where the mediator can effectively have private confidential meetings, caucusing, but we are seeing a lot of lawyer assisted mediations these days, and quite often the lawyers like to be in the same room as everybody else and having those sort of almost plenary sessions as well.
So Karen, can I ask about sessions which are with the lawyers on each side and the mediator only? Do you ever have any of those?
Yeah, so I think that the lawyer's role in mediation has been very clearly set out already this afternoon by Andrew, and I certainly agree that their role is to be the wingman, which sometimes is a sort of whole new role. If you're going to bring lawyers into a family mediation and they're going to support their clients, you would, before the first joint session, have what I would call a professionals meeting, which would be attended by the mediator and the two lawyers. The purpose of that is, again, reinforcing what Andrew has said, is to explain that this is really the couple's process, which is managed by the mediator. And say that the lawyers are really, they're providing vital roles in the provision of advice, but they're not in control of the process. And it's important that they understand what their role is. So that's one of the purposes of the professionals meeting, is to talk about the role of the lawyer and also the scope of the mediation. So the mediation.
And when do you like to have your professionals meeting?
Before the first meeting jointly with the couple. So you would have seen each of the couple for their intake session first, and then I would have the professionals meeting after that if the lawyers are going to attend, and then you would move into the mediation itself.
And can I turn back very briefly to the civil and commercial mediators to ask about sessions with the lawyer and the mediators only, or sorry, the lawyers and the mediator only? Do you find that you get more candor out of the lawyers if you have them on their own?
You can do, and I think that, I don't know what Stephen says about this. I think there's an ethical dilemma here, because I think that lawyers tend to exercise their confraternity to talk about clients. And I think that there is a risk that they will drift into talking about clients in a way that they shouldn't, and certainly without instructions. Although that makes me sound old-fashioned, I know that it happens, and it lends more of an air of informality to what's going on than perhaps it should. After all, you're there on instruction, and I think that you have to be somewhat careful about what you say in private meetings with the mediator. There's no such thing as off the record in the law. It only applies to journalism.
But as a mediator, Andrew, might you call the lawyers together to craftily try and get them to be a bit more indiscreet about their positions?
I wouldn't put it that way. I would certainly bring the lawyers together. I would certainly be happy to act craftily, but I wouldn't be there for the purpose of getting them to move their positions. I would be there for the purpose of making sure that we weren't giving undue influence to the case and having to focus on the case in circumstances where that of itself was a difficulty. Because, of course, the great thing about civil commercial mediation is you simply don't have to focus on the case. It's there as a hinterland, but you can pop it in a box and keep it in the corner and discuss all manner of things which might be attractive to the clients for the purpose of securing an outcome that they can both live with. And I think one of the reasons for speaking to the lawyers, and Stephen may correct me, but one of the reasons is to tell them to stop lawyering.
Thank you, Andrew. Right, we're going to have a prompt stop at 2 o'clock. My last question, I'm going to turn to Stephen in the first instance, very briefly, please. And the drafting of a settlement agreement. As a mediator, what do you think should happen? Do you think that should be done on the day, or if everyone's exhausted, should that wait until another session?
Right.
What are your thoughts?
Here it is in 60 seconds. It shouldn't happen on the day. It should happen when you're drafting your position statement. Bring your draft settlement agreement with you. It'll make you think about settlement, which is what you're there for. Secondly, don't reinvent the wheel. Use one of the two industry standards, the CEDA one, which is on their website, or the PLC one. And thirdly, do not try and improve the deal for your client in the drafting. They've done the hard work. They've made the psychological adjustments to get a deal done. Your job is to write it down.
Thank you. And any observations from the family lawyers about the drafting of agreements at the end of a long day?
Well, we typically would do a memorandum of understanding and an open financial summary after the mediation, not on the day. If we were worried, we might do similar to heads of terms, particularly if the lawyers are there. You would expect them to be drafting that and presenting it to you for you to check.
Karen, do you have anything to add there?
Well, just to endorse that the drafting is passed back to the lawyers. So we would, if the couple are light on proposals that they could tend to move forwards with, we'd record those in a without prejudice document on which they could take advice. If the lawyers are present and they want to make the mediation open at the end, they'd probably provide heads of terms. They might, if they're very swanky, draft a consent order there and then, but they might want to go away and consider that. But I'd endorse what Stephen says, that they're writing up what has been agreed. They're not adding their own nuances at the end.
Excellent. Well, that brings us to 1:59. Thank you very much to all of the delegates for staying with us for the hour, and remind everyone that you can go back and re-listen to this or to the introductory session on the 23rd of April on the Financial Remedies Journal website. Thank you very much for joining us this afternoon. Good afternoon.
Bye.
Thank you. Bye.
Bye-bye.